And within the university system, no, I must place the unions in proper perspective for
Hello and welcome to the program. I am DEJI360. Nigeria's Supreme Court surprised quite a number of people last Wednesday when it upheld the elections of Okezie Ikpeazu and Udom Emmanuel as governors of Abia and Akwa Ibom states, respectively. In doing so, the Apex Court overturned the verdict of the Court of Appeal, which had earlier given judgment against both governors. In the case of Abia State, the appeal court had actually ruled that Alex Oti of Abga won the election, ordering INEC to issue him with a certificate of return. And in the case of Akwa Ibom State, the appeal court invalidated elections in some local government areas, actually ordering a rerun. But all of that is now of no consequence with the ruling of the Supreme Court. In their judgments, which lasted less than 30 minutes, the justices of the Apex Court, led by the Chief Justice of Nigeria, said Governor Ikpeazu and his Akwa Ibom counterpart Udom Emmanuel won the lawfully votes cast and were duly elected as governors of their states. Hearing in the various appeals lasted over 12 hours with intermittent breaks, and the judgments, of course, came late at night. In less than 15 minutes, they upheld the appeals filed by Governor Emmanuel of Akwa Ibom State and Governor Ikpeazu of Abia State, declaring them duly elected. Let's show you the scene now at the Supreme Court after that judgment and some of the reactions that followed.
This is a great victory for justice, for the rule of law, and for democracy. And I also want to thank the President, Muhammadu Buhari, for giving an opportunity for the independence of the judiciary, because that is what has culminated in the judgment of today. So I give kudos to the President for this. And in Akwa Ibom State, for instance, we don't take this as victory for any individual. We take it as victory for God. Because what happened in Akwa Ibom was justice. And my prayer is that those who feel aggrieved will feel the need to come and join hands with the now judicially confirmed governor of Akwa Ibom State, Udom Emmanuel, to build the state. So that together in love and together in unity, we can bring more progress upon the state. But I can tell you that what the Supreme Court has done today has shown the whole of Africa that democracy has come to stay in Nigeria.
I think we should commend INEC. The second point I want to make is that it is time for Nigerian politicians to accept defeat. If you have lost, you have lost. Go and prepare for the next one. So don't let us believe that we must at all times fight the battle from beginning to the end. Well, the third point I want to make is that the judiciary has been the strongest pillar in our venture for democracy since 1999. If not for judiciary, Nigerian democracy will not be where we are today. They have established various principles and various common law positions that have sustained the democracy. And so we must refrain from very puerile allegations that Nigerian judiciary is corrupt, Nigerian judiciary is weak, Nigerian judiciary is not the best. I can boldly say that Nigerian judiciary is one of the best in the world.
We'll build back our people, prepare them for the next outing. We still have some elections, House of Assembly and other elections in the state. We'll go back, strengthen our people and go for those elections. And for now, we will want to work with everybody in Akwa Ibom State to make sure that we give support to the President Buhari's administration and build back everybody.
Well, joining me now to talk more about this judgment is Libros Oshoma, a lawyer and political analyst, and Chief Godwin Wazirike, also a lawyer and political analyst who joins us from another part of Lagos. Gentlemen, thank you very much for coming on the program. Let me start with you, Chief Wazirike. What would be your reaction to this judgment, taking a lot of people by surprise?
Well, it did not take many of us by surprise. We expected it. We only hoped that the threats or the complaint by Mr. President of Nigeria, Muhammadu Buhari, that the judiciary is an obstacle and has been so on his way since 2003 will not affect their reasoning. And I can tell you that going by the number of hours it took for the judges to reach a decision, it meant that they need to convince themselves that they were on the right path. And many of us who are lawyers followed carefully the issues at stake. In Abia State, it was more of what do we do with the 3 local governments? We think there was something wrong. Do we add or do we disenfranchise the people? In Akwa Ibom State, it was a case of whether there was violence, whether there was free and fair voting, and so on. Now, many of us took time to look at the implication of disenfranchising the people. You don't do that. This is a democracy. In the case of Akwa Ibom, in fact, left to the petitioners at the lower tribunal, the whole thing would have been given in their favor. At the same time, they were alleging non-compliance. As a lawyer, I know that if I go to court and say that this election was not fair and fair, in other words, there was non-compliance, I must show that it was so substantial that it affected the outcome. And I do not believe any of the parties, either in Abia State or in Akwa Ibom, ever did that. But the Supreme Court, remember, has a chance to look at the reasoning of the Court of Appeal and also to look at the reasoning of the first tribunal. So we were not surprised.
Okay, let me just pause you there now and come back to Liberos in the studio here. Liberos, were you surprised? And let's not also forget that the Supreme Court has actually not given reasons for this judgment. In the case of Akwa Ibom, we understand on the 15th of February, and in the case of Abia, it says it will give reasons on the 26th of February. But let me get your reaction.
Basically, Rivers State
was a clear pointer.
Was a clear pointer to what would happen with Akwa Ibom. But for Abia, I had expected, I would say it, I had expected that the Supreme Court will order
a
rerun
in those 3 controversial local government areas.
In the controversial Ugwa area, senatorial zone. But for reasons best known to them, they decided otherwise. And until we'll begin to read, the entire judgment and know why they reasoned that way, I will not say I was a bit taken aback for that of Abia. But for Akwa Ibom, I already knew where it was going. And then also, I must say this because it's always very quick for us to be silent when we discuss these rivers and Akwa Ibom. We are silent about the position of the Supreme Court in that of Lagos. If you remember, that was also the reasoning of the Court of Appeal and the Supreme Court in that of Lagos State. And basically, I would preempt the Supreme Court that the reasoning will be about the card readers and the voters register, because these were the basic issues that came up.
From what has come out so far, it's like the Supreme Court did not lay much emphasis on the card readers.
Basically because also it's a pointer to the fact that when you make regulations, you should try as much as you can to make them part of the laws. Otherwise, they will just end up as regulations. And
how do you mean by that? INEC did not make the card reader as part of the law.
If you remember,
the use of the card reader.
in Amechi's case, then the Supreme Court had given a judgment before Amechi's case. That was the judgment of this man from Ararume on illegal substitution. And the Supreme Court did say that the party had no power to substitute Ararume. And so to that extent, Obasanjo said he had no candidates. And then that for Rivers, also Amechi was illegally substituted. And to sound a note of warning to the political parties, the Supreme Court gave that judgment that he gave, that, look, having substituted this man illegally, the party won the election, the victory belongs to the party. The man should be, the beneficiary of that victory. Immediately, the National Assembly corrected that position by introducing Section 141 of the Electoral Act. And so in the same vein, I would have expected that the moment these card readers were introduced, in 2011, before the 2015 election, some of us had argued that INEC immediately after the 2011 election went to sleep until a few months to the 2015 election. At that time, I had expected them also to liaise with the National Assembly, this new innovation that you are introducing. Try as much as you can to amend the electoral laws to include this your innovation. Because also, if you remember, some members of the PDP had queried the introduction of card readers, alleging that it was electronic voting. Was this man?
That's quite true.
From Cross River State, the SAN from Cross River State, was at the forefront of that that matter at that time. So I would have expected INEC at that to use that opportunity to include, to ask for an amendment so that it would be part of, the requirement of the Electoral Act. Because they had also insisted that without the card readers, you will not be allowed to vote because they have powers to make such regulations.
Let me just pause you there and go back to Chief Uwazurike. Chief Uwazurike, do you think in any way at all that, when we eventually see the reasoning of the Supreme Court, that it will basically revolve around the use of the card reader during elections, that the Supreme Court will basically say, well, it's not in the law and it's not sacrosanct whether the card reader was used during voting or not?
Well, I'm aware that Supreme Court has in two recent decisions given reasons. One on issue of card reader, the other one is on who is a candidate. On the issue of the card reader, the Supreme Court was very clear that the law as it is today, the Electoral Act, says that all voters must see their names in the voters' register. In other words, reliance is placed on the voters' register as the first thing you do when you want to go and vote. You are accredited because your name is there. At no time did the Electoral Act say you must use any other thing. So the voters, the card reader and so on, as far as I understand it, it's a mere guide, it's a mere assistance. And INEC intended it to be so. For if not, they would have gone to the National Assembly to have an act enacted, to have a law made, making it compulsory. The impression given by INEC before the election was that the card reader was compulsory. And the use of card reader failed nationwide. And Supreme Court has since decided that it is a mere guide, it's not the law. And as long as it is not the law, nobody should place undue emphasis on something that is not the law. This is why in Rivers State, remember the decision that the people did not use the voters' card reader. Therefore, whatever was done without it was null and void. And that is why all the legislators in Rivers State are now suffering, because their cases stopped at the Court of Appeal, where that position was held that without the card reader, you can't do anything. So they have to go for re-election because their cases have no opportunity of getting to the Supreme Court. But it also means that in all future cases, all courts, from Court of Appeal to the Election Tribunal, must rely on what the Supreme Court has said. As it is today, the law is that the use of the card reader is not compulsory, and it's not going to be a determinant as to the number of people who actually voted. And in reality, the card reader failed.
Hold on now. That law can actually change if, for instance, INEC goes to the National Assembly and the National Assembly decides to make it the law.
Yes, they should do that. In fact, I urge them to do that. But before they do that, they must assure us that that card reader is working, because it failed ignominiously in my own area. I couldn't vote with it throughout in all the elections. It kept on saying, rejected. You are not a human being, rejected. So for me, it's a failure. My view is that if INEC wants us to use the card reader, wants to make it compulsory, they must first and foremost do their homework. It's only when you do your homework that you can go to any other person, including members of the National Assembly, to convince them that the use of the card reader must be compulsory. But for now, it is still experimental and must never be a sine qua non.
Let me come back to you in the studio, Liberos. I mean, before, just after the election, we know, or probably before the election, we know the Chief Justice of Nigeria is on record, is on record to have said, look, the courts will not be used this time to nullify elections. Do you think this is the court now living up, or the Chief Justice now living up to those words he said ab initio, that look, he made it abundantly clear right from the very beginning that the courts will not be used to nullify elections, as we have had in the past?
No, basically, whether you want to use the courts or whether he made a statement or not, the basic thing is once you do your homework very well, or that the election did not meet the electoral standard, once you're able to prove that, there is nothing anybody can do about it. The court will have no other option but to nullify that election. But if you look at all these cases that we're discussing, the one for Lagos State came first.
Exactly.
That was where the Supreme Court, because the issue in contention at that time was the card reader. The PDP, the allegation was that so in some areas, the number of registered voters, the number of actual voters were more than the number of people with card readers that the card readers captured in those areas. Because if you remember also, there were areas where the card readers were malfunctioning, exactly, and they had to resort to incidents form.
Yeah, exactly.
And so the Court of Appeal in Lagos and ditto the Supreme Court did rule that the card reader, not being a requirement of the Electoral Act, could not be used to judge the actual winner, that what the Electoral Act specifies is the voters register. And so, if you remember, the moment the Court of Appeal in Abuja then on the Rivers State election ruled on the issue of card reader, and that since the number of actual voters were more than the number of card readers and the incidents form, Wike did raise an alarm that how come that there is a conflicting judgment, one from Lagos and a different one on Rivers from Abuja. And then also, there were also statements credited to some justices, even the Chief Justice of the Federation, that it was alarming that conflicting judgments were coming from the Court of Appeal on the same issue.
How come we had such a situation? Why didn't the appeal court at that time, like in the case of Rivers, take a cue from the judgment of the Supreme Court on Lagos State?
For me, it would be difficult for me to sit down here and say this is the reason, because these are judges who probably look at these issues from different perspectives, different point of view, and also depending on sentiments involved. But at the Supreme Court now, what they basically did was to follow their earlier position in that of Lagos to say, look, because also the moment the Court of Appeal, and then also don't lose sight of the fact that the moment the Court of Appeal gave those judgments, what the argument at the Supreme Court would be that for the APC to argue in line with the position of the Court of Appeal. And so that argument will now be centered on usage of card readers, number of actual voters, number of registered voters. Why that of PDP would be to argue in favor of that decision that had emanated from the Supreme Court before, on that of Lagos, that what you need to look at basically is the electoral register. And so, with this ruling, even though reasons had not probably expand the reasoning, with this ruling now, what it means is that INEC should put his house in order and find a way of most of these their regulation, including the regulation that caused the crisis in Kogi. INEC should find a way of putting these regulations together and making them part of the electoral laws, just the same way the National Assembly did with the Amechi's case. Otherwise, we would have taken 10 steps forward and take 6 steps backward, because with what we are seeing now, it's like we are making progress, yet we are not making progress. And then also, I want to quickly say this also. I've heard people express dissatisfaction and called Supreme Court justices' names and alleged corruption, bribery, and all of that. Law does not work that way. The law is a different thing altogether. The court had consistently maintained it's not a Father Christmas. You don't get what you didn't ask for. We should find out what was argued at the Supreme Court and what are the precedents before now, before we begin to call names. And then also, when the court gave judgment in Ekiti to Fayemi, gave judgment to Aregbesola, and they also gave judgment to Oshomale. We all celebrated these people as victory for democracy.
No, it's always
now
the case.
also, we
it's
should also
I mean,
see it as
if some of
victory
these
for
cases,
democracy.
there's no question, Chief Wazirike, that if some of these cases had actually gone against the PDP, would be singing, some of the PDP members who were singing a different tune.
Calling the president's name by now.
Exactly. For instance, we had the former governor of Akwa Ibom State, who is now the Senate minority leader, praise President Buhari, saying at least, you know, for giving the judiciary the opportunity to be independent.
To work freely.
But if this judgment had actually gone against his party and gone against his candidate, it would have been a different song altogether, isn't it?
Yes. Let me put it this way. A politician wants to win, no matter how. All he wants is victory. And if he loses, then there must be a scapegoat. You know, in this country, we say if the facts are against you, go for the law. If the law is against you, go for the facts. If both the facts and the law are against you, you go against the judge. In this case...
Now, where did you get that from?
Well, it's something you learn in law practice, which we know is bad. And when a lawyer resorts to that, you know that he has become desperate. You know, in the case of Osun State, which my learned friend here mentioned, when the judgment went against the then PDP man, he alleged a lot of corruption, and he caused enough noise, enough rumpus, and the president of the Court of Appeal was suspended. From there, the man retired. Now, the very man who petitioned the National Judicial Council has gone to join APC. He now stands behind his former opponent, and of course, he's one of those abusing the judges of the Supreme Court today. Let me put it this way. The judges of the Supreme Court are men and women of integrity. And by the time you get to that seat, you must have dodged a lot of bullets, because the road from High Court to Court of Appeal to Supreme Court is full of landmines. Every judgment a judge gives, there is a petition. You always ask people what they mean. They say, the judge collected bribe. Oh, yeah, now come and stand up and say it. They say no. Some of the petitions against judges are from fake addresses. So our present Supreme Court, I will stand by this Supreme Court. And this is why I was shocked that our president was lamenting about the judiciary, forgetting that judiciary is there established by the Constitution as an independent body. If the executive picks up a man, after 48 hours, the executive does not charge the man to court. What happens? The man must go to the judiciary to ask, why am I being detained? If the judiciary grants a man bail, the executive has no option. Under our Constitution, executive is bound to pay the price of executive lawlessness. In other words, when a man is granted bail, what is expected? Everybody obeys. If the legislature is fighting with the executive, both of them must go to the judiciary. So all these men, most of whom are almost 70, men and women, they must be respected. And believe you me, the kind of reading and the kind of observation they make is not something you pick up on the road. A justice of the Supreme Court has seen many days. He has seen many battles. He has seen lawyers and he has seen the law. So whenever you find them giving a judgment which you don't like, please go back to your lawyer and ask him in confidence, what do you think of this judgment? And a good lawyer must tell you the truth. As it is today, I know a senior advocate who is busy lashing the Supreme Court pages of newspaper. Why? Because his friend lost the control of the state, from which was benefiting a lot. I mean River State. He benefited a lot from that state. And today is one of those abusing the judges of the Supreme Court. That's very, very bad.
We're going to shift gear now. We're going to discuss something else. We'll take a short break, and When we come back, the Supreme Court has actually ordered Senate President Bukola Saraki to go back and continue with his trial at the Code of Conduct Tribunal. So I'll be getting your reactions to that. Stay with us, don't go away. Every day, every hour, and every minute, news break in Nigeria. Things happen so fast, it's most times difficult to track and comprehend them. But that's what we do right here on DEJI360. 2015, would you want to come back again?
It's like asking Jesus Christ if he knew he was going to die, will you want to come back as the savior of the world again?
We do not just help you track the stories, we break them down, explore all the angles, analyze the issues so that you can fully comprehend the stories and use them to make the right decision.